So to begin with, I'd like to first show you the matrix of jurisprudence. So when we refer to the matrix of jurisprudence, this is largely what I'm referring to. Every possible legal concept, theory, doctrine, anything that you could possibly think of would effectively be in and out of this fairly complex looking diagram, but it really is not. The journey would start with rule of law. I'll explain to you the ingredients of rule of law. We'll go through each of the ingredients of the rule of law in detail. And while we do so, I'll also explain its related applications. And the concept of constitutionalism is effectively based on rule of law. And there are some dominant themes of constitutionalism which overlap with rule of law. We'll cover them in the course of the lecture as well, and we'll apply them as we get to do so. So let's first understand this matrix. I'd like to believe that rule of law is the big bang of constitutional law. It's the big bang of law in general. It's the Higgs boson. It's the start of everything else. It all starts honestly with a very simple choice. The choice is, do you trust the person in power, or do you trust the office that the person holds while the person is in power? So the decision of rule of law actually begins with a simpler decision of rule of man versus rule of law. Now, rule of man simply means that the person in power gets to do exactly what they want to. And rule of law means everything is governed by a law. The law is also made by the man. The law is also made by representatives. But the law is more important than the people who have the power to make the law, implement the law, or adjudicate the law. And that's a distinct difference. The Latin interpretation or the Latin translation of rule of law is lex rex. The Latin translation of rule of man is rex lex. So every country would effectively be choosing what is called between rule of man and rule of law. And most democratic countries, and this is the important part, democratic countries will necessarily choose rule of law. If you are a democratic country, that means rule of law is something that you would compulsorily want to choose. Why? What is the relationship between rule of law and democracy? If democracy is a reflection of public will, if democracy is about ensuring that the aspirations of the people are reflected in the government, if democracy is about the people choosing the people who will govern them, then rule of law ensures that the people in power do the right thing in the right way, in the right manner, for the right reasons. And that is why there is a positive correlationship between democracy and rule of law. Now, there would have been several reasons for several countries to choose between the two. And India chooses to be a rule of law country for primarily 4 reasons. Reason number 1, our colonial history. Approximately 200 years of colonial rule, and the legal part of it, the constitutional legal history, would be dealt with in the forthcoming lecture. The colonial part of it made us understand how perverse and how difficult, irregular, biased organizations of government can be. We know the detrimental laws, the biased laws, the one-sided laws that the Britishers have imposed upon us. And therefore, we always wanted to ensure that we have a fair system of government. Two, unlike several Western countries, more specifically the United States, where the states collectively came together and said, let's make the United States of America. The states came before the center when it comes to the US. In India, it was the exact opposite. In India, power was transferred to the Constituent Assembly, and it was the responsibility of the Constituent Assembly and the leadership at that time to consolidate and integrate India. Now, for those reasons, India is partially a voluntary federal nation and partially, one could say, semi involuntary. There were a lot of instances where there was a lot of hesitation, there was a lot of resistance, there was certainly a lot of negotiation. So, if you have to convince a princely state to join India, you cannot convince them by saying, you know what, we've got a great leader in power. You've got to convince them by saying, our relationship is going to be governed by a law that's going to be bigger than the people in power when the law is to be operated upon or when the law has to be executed. So, our reasons of voluntary and for voluntary federalism is a very strong factor in India choosing to be a rule of law country. Thirdly, the sheer diversity quotient makes rule of law an obvious choice. The diversity quotient means, unlike again several countries in the West, India has always been home to all religions, all cultures, all groups. We've always been an incredibly diverse country. We have always been an incredibly welcoming country. So, whenever there is diversity, there will always be a majority, there will always be a minority. And whenever there will be a majority and whenever there will be a minority, no matter what kind of a majority, no matter what kind of a majority or a minority, it doesn't matter what the nature might be, diversity will always have the chance of conflict. In such a case, the law must be indiscriminate. The law must be fair, the law must be unbiased. And if actual power is with the law, it will make sure that the majorities don't cross a line and the minorities are adequately protected. But if the person in power has all the law, has all the power, has all the authority to do whatever they want to, then depending on who the person in power is going to be, and democracy is nothing but the law of majorities. So generally what would happen is that a person in power would necessarily, or if not necessarily, most likely come from a majority. And that could be leading to some questionable policy outcomes. So India chooses to be subject to a bunch of laws. Those laws that will stop the people in power from crossing a line and will make sure all interest groups are adequately represented, protected, and taken care of. And fourthly, our socio-economic indicators. When we became independent, as per our first odd census, which was I think conducted in 1951, India's literacy rate was about 15-16%, which means 85% of India could not functionally read or write. The female literacy rate of India was under 9%, which means about 91% of India could not read and 91% of women could not read and write. Now, in a circumstance like that, where literacy is so disadvantaged, where poverty is so disadvantaged, where there are several other developmental challenges, rule of law becomes an equalizing factor. It will protect those in a larger capacity who need more advancement. It will make sure there is some form of equivalence of opportunity, of platform, of ability, of a chance to redeem oneself. And for these four reasons, we choose to be what is called a country based on rule of law. Now, very categorically, the word rule of law is not mentioned anywhere in the Constitution, though the Supreme Court, in a variety of its judgments, have recognized rule of law as a concept. In fact, we also recognize rule of law to be an element of basic structure. But the word rule of law per se does not find any mention whatsoever in the Constitution. It is a Diceian concept, and Dicey was a very, very prominent uh, English legal expert. The full name was A.V. Dicey. It's not relevant for the prelims exam in any manner. So, when he had originally written what the concept of rule of law is, he had kept the UK's legal system in mind. And what we know about UK's legal system is the fact that they don't have a single written codified constitution. They were, at least at that time, a functioning monarchy with at least some substantive powers. So the original Diceian understanding of rule of law versus what is the globally accepted principles of rule of law, there is a little bit of a difference. So, based on Diceian concepts of rule of law, which you would also see similarly in several Indian manuscripts and Indian texts also, there are three basic principles of rule of law, three basic pillars of rule of law. The first of it is called the lack of arbitrariness, the absence of arbitrary power. It is the first and the most important rule of law. When we use the word arbitrary, arbitrary simply means when somebody is doing something on their own. There is no substantive law that is allowing you to do something. You are doing it because you think it is the right thing to do. You are applying your mind or not, but you're independently taking a decision which sounds without any justification. There's not enough rationale for you to do what you want to do. And therefore, arbitrariness is one of the most important dangers to the concept of rule of law. Now, when we say this, what do we mean? We mean that if there is an arbitrary law, or if there is an arbitrary action taken by the executive, which is largely the case, then the law as the supreme of it, the law as the heightened concept of it, the law as the superior entity to it, that loses its charm. When we say rule of law, it means everything happens because of a law. When we say rule of law, means every power originates because there is a law that provides for it. For example, in a few lectures from now, when we do the executive, I will say that the executive powers of the union are coextensive with the legislative powers of the parliament. That's simply an application of rule of law. The powers of the executive to implement the law will only be limited to the powers of the parliament to make the law, which simply also means that the executive can only implement those things on which the parliament has or would have made a law on. And that's the larger idea. So the law is the originator of power. If there is no law, what you're effectively being is arbitrary. So it becomes a very, very important concept. So this means when we speak about arbitrariness, it actually applies more to executive action and a little less to legislative action. So arbitrariness is largely associated also with administrative law. It's also associated with a more complicated concept like delegated legislation, when the executive is empowered to make rules on something. Are they crossing a line? Are they making rules on something that the law has not given them the powers to make rules on? So, for example, if there's a right to education rules, it's because the Right to Education Act allows for the right to education rules. But the right to education rules that you've made should be because of what the Right to Education Act allows the Education Ministry to make rules on. So, therefore, it is a very, very sensitive concept, extremely important. And therefore, when you have to eventually prove arbitrariness, you would therefore be dealing with two very important legal concepts. First, are you following a procedure which has been properly passed by the law? And second, is the law and the procedure inherently fair or not? And that's why you have procedure established by law and due process of law. Two very, very important interpretations and two very important terms. In fact, procedure established by law is explicitly under Article 21, but due process of law has been interpreted by the courts in several decisions. The most important of it, the most landmark of it, happens to be the Menka Gandhi case. So, when you are trying to figure out whether the procedure was fair or not, you have to figure out where there was a conflict of interest, or whether you had given an adequate opportunity to the other person to present their side of the story. So, therefore, related to the due process of law, you would have a concept called principles of natural justice, and this is directly related to arbitrariness. Now, procedure established by law and due process of law also ensure the law is good enough to rule us. For there to be rule of law, the law should be worthy enough to rule over us. And therefore, if the law is procedurally sound, the law is substantively sound, then the law is good enough to be above us. And that's also why these become very important hallmarks of rule of law. So, which is why you'll see the journey starts from rule of law, comes to arbitrariness, that for there to be rule of law, there should not be any arbitrariness. And how do you ensure there is no arbitrariness? Is by making sure there is procedure established by law and there is due process of law. Are we okay with this? Do we understand this? And if that is the case, to prove due process of law, you must be able to also attach the larger concepts of principles of natural justice. So the journey starts from rule of law, comes to arbitrariness, comes all the way to procedure established by law and due process of law. This is one arm of it. The second arm of rule of law, the second pillar of rule of law, is equality before law. The law cannot be superior to us if it doesn't treat us equally, if it doesn't treat its subjects equally. And very happily, what you have is equality before law categorically mentioned under Article 14 of the Constitution. So this effectively means that the law should not treat the government specially. The law should not treat government servants specially. There should not be an unnecessary amount of immunity unless it's absolutely necessary. So rule of law is heavily dependent on what is called equality before law, because equality before law means that everyone is treated equally before the law. And of course, over a period of time, you'll understand equality just doesn't mean everybody to be treated equally, but it also means that people who should be treated equally are treated equally, and people who are different, who are disadvantaged, where there are special circumstances, and therefore there could be some amount of what is called differentiated treatment, which is why when you study equality before law, you also in the Constitution also understand two very important concepts. Again, both of these concepts are not explicitly mentioned in the Constitution but have been derived through several Supreme Court judgments, and they are rational nexus and intelligible differentia, which means that by chance, for any reason whatsoever, you are not treating two people the same way. The first question is the basis on which you're not treating two people the same way. Is that basis reasonable? So, therefore, rational nexus. And by treating two people differently, you're trying to achieve an objective. So, if you are treating two people differently, are you necessarily able to achieve that objective? So, for example, let us say your objective is social justice, which means that people who come from disadvantaged castes must be given some relaxations, some special provisions. So, you have basically bifurcated people on the basis of, let's say, upper caste and lower caste. Is that a reasonable basis? Sounds like it. By doing this, if you're able to ensure that people from lower castes are able to get better employment, better reservation, better opportunity of education, then it sounds about right. So, therefore, equality before law allows you to have some form of equity before law. And the two principles would be rational nexus and intelligible differentia. And both of these, again, are not mentioned in the Constitution, but of course would find some important mentions in several Supreme Court judgments. Now, the third principle of rule of law, as we understand it to be, is the grand old legal spirit. What is law without the legal spirit? But what is the legal spirit? The legal spirit is your ability to go legal. For you to go legal, you've got to have rights. And not only should you have rights, you should also have a mechanism to enforce those rights. You should have the ability to challenge something if it takes away your rights. You should have the ability to question authority, to question government if your rights are being taken away. So, legal spirit is effectively the ability or the being to have some legal recourse, some legal correction. And for that to happen, you should have the courts in the country with the powers to review something that is taking your right away, more simply called the concept of judicial review. But again, judicial review is also not categorically explicitly mentioned in the Constitution. It is derived from various articles. It is in fact a part of basic structure. It is extremely important in terms of ensuring checks and balances, which is a natural corollary of separation of powers. But the term judicial review, as the term stands, is nowhere mentioned in any form or manner as far as the Constitution is concerned. And for the courts to be able to independently, for the courts to be able to efficiently review anything that has taken your right away, it mostly would be a law or an action by the executive. In such a scenario, you would effectively require an independent judiciary. A judiciary which is not biased, a judiciary which is not having any compulsion whatsoever to favor a certain side. Again, the term independent judiciary is nowhere mentioned in the Constitution. It is derived through various provisions. One of them could effectively be the collegium system of appointment. And we do recognize independence of judiciary, in fact, as basic structure. In fact, it was because of independence of judiciary being basic structure we struck down the 99th constitutional amendment as being unconstitutional, as it had proposed an alternate system of appointment to judges, which would involve the legislature and the executive. This alternate system would therefore be called the National Judicial Appointments Commission. So, yet again, for there to be rule of law, you should be able to question anything which is taking away your legal rights, and therefore that's called legal spirit. And for you to be able to do that, you should be able to have judicial review and independent judiciary. So, if in the prelims they ask you which of the following is an outcome of rule of law, and they say rule of law is related to judicial review, yes, because without judicial review there cannot be rule of law. You cannot decide what is good law or bad law unless there is judicial review. And for you to decide whether there is good law or bad law, you should have what is called independence of judiciary. Now, these are the kind of questions the prelims has been asking of late. They're taking a grand concept and they're linking it to very, very tangible constitutional principles. So, therefore, rule of law has three major pillars. Each of these three pillars will have a degree of applications. Now, if rule of law means that the law is more powerful than the people who are implementing the law, and the people who are implementing the law are effectively the state. So the rule of law is effectively a mechanism to limit the powers of the state. And the theoretical understanding of anything that limits the powers of the state is the concept of constitutionalism. And constitutionalism allows you to restrict the powers of the state, allows you to build whatever you can, however you can, to restrict the powers of the state, which is why rule of law is actually the basis of constitutionalism. So there cannot be constitutionalism if there is no rule of law. And this is true because if constitutionalism is to restrict the powers of the state, then the legislature, the executive, and the judiciary are branches of the state. Giving any one of them any superior power of the other will take away the balance, and therefore it should ideally be the law which restricts the powers of the state, and therefore rule of law becomes that entity that restricts the power of the state. And when you build a constitution which is an application of constitutionalism, is nothing but rule of law in very tangible form, which is why the constitution gives reference to procedure established by law. It's through the constitution you come up with things like the rational nexus. It is through the constitution that you're able to come up with things like judicial review. So, therefore, what ends up happening is rule of law is the basis of constitutionalism, yes. And constitutionalism restricts the powers of the state, yes. And therefore, anything which leads to supremacy of law and leads to limiting the powers of the state is effectively interrelated. So, for instance, if the law is arbitrary, that means the law is not treating people equally. And if the law is not treating people equally, it is violating a legal right. And therefore, I have the powers to review that law, and I will be able to do it effectively only and only if I have an independent judiciary. And if the law is treating us unequally, that means either the basis of classification is wrong, or the objective that you're trying to achieve with that classification seems to be odd. And when you do all of those things, you are effectively questioning the way in which the law has been passed, or the way in which the law is being applied, or is the law inherently good or not. So the circle gets completed. So this rather seemingly complex flowchart is actually the heart and soul of the Magna Carta, Indian polity, constitution, and everything else. So think of any constitutional principle that comes to mind. Let's say federalism. Now, federalism is division of powers between the center and the states to ensure what? There is no arbitrariness. And this means that rule of law has a relationship with federalism. And constitutionalism is limiting the powers of the state. The state includes the center and the states. So if I divide powers between the center and the states, what I'm effectively doing is limiting one's power over the other, which is nothing but, again, constitutionalism. So federalism applies to arbitrariness, applies to constitutionalism. Take, for example, doctrine of basic structure. Doctrine of basic structure applies to the parliament's power to amend the constitution. They cannot randomly, arbitrarily amend whatever it is that they feel like. And therefore, if they cross a line, if they violate a doctrine of basic structure principle, then because of legal spirit, I can review whether that actually violates the basic structure doctrine. And for me to tell you what is an element of basic structure doctrine or not, I've got to have an independent judiciary. Something as large as federalism or basic structure to something as simple as the powers to issue an ordinance by the president is coterminous with the powers of the parliament to make laws, is nothing but rule of law to ensure there is no arbitrariness, and in case there is a problem, there is legal spirit which allows you to judicially review. So the fact of the matter is, this is the Big Bang. Everything that happens because of this ecosystem. Now let's break this ecosystem. Let's look at each fragment in a fairly decent amount of detail and understand exactly what each of these mean. Why is this important? And arbitrariness largely looks at executive action. When we say that the law is treating two people differently, therefore it's violating equality before law, it largely looks at legislative action. And the legal spirit looks at the powers of the judiciary. So through the three pillars of rule of law, you're able to identify the three branches of the state. Every possible combination running from one point to the other is possible because of this matrix of constitutional universe.